Well, hello, everyone. Thank you for joining our webinar regarding challenging issues in UDRP and CDRP cases, emerging trends, and how to win your next case. My name is Barry Penner. I am the Managing Director of the Vancouver International Arbitration Centre and its wholly owned subsidiary, the Canadian International Internet Dispute Resolution Centre. These two organizations have been around for some time, but under a different name. VANIAC, or Vancouver International Arbitration Centre, has until last year been known as the British Columbia International Commercial Arbitration Centre, established in 1986 as a joint effort between the federal and provincial attorneys general of the day back in 1986. That was John Crosbie at the federal level, the late John Crosbie, who was then the Minister of Justice for Canada, and Attorney General for British Columbia known as Brian Smith, QC. The centre was established to coincide with Expo 86. It was part of a government initiative to help make Vancouver more of a financial center globally. Last year, we rebranded, modified our name, recognizing that Vancouver is actually better known internationally than the name British Columbia. Some people overseas would tell me they thought it was a country somewhere in South America. So learning from the Vancouver Olympics of 2010, we've rebranded our name to Vancouver International Arbitration Centre. As mentioned, we have a division or wholly owned subsidiary known as the Canadian International Internet Dispute Resolution Centre, and it focuses on internet domain name disputes. For many years, approaching 20 years now, we've been handling disputes for the Canadian Internet Registration Authority, CIRA, doing .ca domain name disputes. And a few years ago, our organization decided to approach ICANN, the International Corporation for Assignment of Names and Numbers, to become one of their service providers for handling .com and other disputes. So that work started in late 2019. We launched a functional website that's very interactive under that domain name CIIDRC.com, .org. So that's a little bit about our organization. Just a bit about me. I'm a former Attorney General myself from British Columbia, and I've been the Managing Director of the Arbitration Centre in Vancouver, first BCICAC or British Columbia International Arbitration Centre, and now VANIAC since 2017. So without further ado, we'll just move on to our next slide. I'd like to introduce our esteemed panel. Very pleased that we have Michael Ertl, co-founder of Practical Resolutions Incorporated, was established in 2011 to help parties resolve business and commercial disputes in an efficient and cost-effective way through facilitated negotiation, mediation, and, if necessary, arbitration. Michael is one of Canada's most experienced and qualified commercial dispute resolution professionals. He has more than 25 years' experience as a commercial lawyer, specializing in technology and intellectual property. Michael is a director of the ADR Institute of Ontario and the ADR Institute of Canada. He is a past president of the Intellectual Institute of Canada and a past director of the Canadian IT Law Association and a past chair of the Toronto Computer Lawyers Group. So we're very pleased to have him. And by the way, he is a member of our roster of arbitrators at the Arbitration Centre. David S. Lipkus received his Juris Doctor from the University of Detroit Mercy School of Law in 2008. He also received a Bachelor of Arts degree in 2005 from the University of Western Ontario. David became a member of the New York State Bar in 2009 and was called to the Ontario Bar in January of 2010. He's been a member of the Kestenberg Siegel Lipkus LLP on a full-time basis since 2008. David regularly conducts web-based training of law enforcement throughout the year on behalf of several brand holders. Since joining the firm, he manages all internet-based counterfeiting investigations and enforcement. And for more information, you can visit their website. So again, I'm very pleased to have these gentlemen here with us. And on the next slide, we'll just see a bit of an overview of what you can expect to learn about. You'll learn about the Canadian International Internet Dispute Resolution Centre's role in administering domain name disputes under both the Canadian Dispute Resolution Policy and the Uniform Dispute Resolution Policy established by ICANN. Just for ease of reference, that acronym of ours can be a mouthful, but we've just come to call ourselves CIDRC. And I think henceforth I'll refer to it as such. UDRP and CDRP overview, we'll get into some of those key similarities and differences, and then zero in on some case studies, which will further illuminate some of the key differences in evidence that need to be marshaled if you want to be successful representing your client. We are also going to try and allow time for a Q&A session. So I just ask that as questions come up during the presentation, use the chat feature to indicate what your question is. I will attempt to serve as a moderator and will pose the questions to either one or both of our presenters. So feel free just to, as questions arise, to submit those through via the chat feature. And a reminder that this session is being recorded, and assuming everything works out, we plan to post it on our website for future reference. So without much further ado, we're on to the next slide. And I think this is where Michael takes over. Actually, I think maybe this is where I continue.
Yes. Thanks.
Sorry about that. Sorry to scare you, Michael. CDRP, as I said, I refer to us, is the most recent institution. We were accredited by ICANN to administer UDRP cases in 2019. We became only the second such organization accredited by ICANN in the Western Hemisphere. There are several organizations in Europe and a couple in Asia, but we're only the second organization in North America and the only, pardon me, in the Western Hemisphere, and the only one in Canada. And as you can see, this is a screenshot from our website. When you go into our website, you're faced with a choice. You can, if your matter's governed by CDRP policy, you click on the red side, and for ICANN type disputes, you go to the UDRP side of the screen. Next slide, please. And this is again a grab from our website to show you what you'll see. We've tried to make it very user-friendly and intuitive, so that even lay people potentially could use it. Although we do notice that most of the time people are represented by counsel. So there's a way to file your complaint right online, and also to respond to a complaint. And you can check back from time to time on the progress of documents being filed and to see what state things are at in terms of timelines. Next slide.
Now you can hand it over, Barry.
I was about to say, I think it's at this point that I'll now hand the baton over to Michael.
Thanks, Michael. I will start with this slide. And I know I speak for both Michael and I that we are very excited to have the opportunity to present to you today. And thank you to CDRP and to Barry for the kind introduction. On a personal level, I scrolled through the list of all the attendees, and it's nice to see so many familiar faces. So hello to everyone that's joining. I'm here today, obviously, to give the counsel perspective because I represent brands. And I'm not embarrassed to admit that I am inherently biased on the side of the rights owner. And what that means is I'm a pro, or my clients are trademark, which means I'm always on the pro trademark side. And although I have, believe it or not, received telephone calls from squatters and from registrants, you will never see me responding to these types of complaints, unless, of course, it's on behalf of a what I'll call trademark owner versus trademark owner style dispute. So just before we begin, I do want to provide a very quick disclaimer. The views that I share today are my own personal views. These are not the views of my client, and these are not the views of the law firm either. And so now that I got that out of the way, it's on to the more fun stuff. And obviously, this is a more intermediate advanced level course, so I don't want to go into detail as it relates to the overview, but I also don't want to gloss over this. And sometimes it's a nice reminder to review really the elements that are required to be proven in these types of cases to succeed before we get into, by way of example, some of the similarities and differences in the CDRP versus the UDRP, and then, of course, specific case examples. And the most important lesson and value add that I can give is as it relates to, what's the first thing you should do when you're hit with a domain dispute and you have to either give advice to your client, or if you're representing the registrant, you need to respond to one of these disputes. What do you do? And the first thing that you should do in every case, and it's the first thing that I do, is I open up the policy. whether it's the CIRA domain name dispute resolution policy or whether it's the UDRP policy. That policy is, for all practical purposes, going to guide you every step of the way. It's going to help you craft your arguments. It's going to help you think about what you need to do to prove to succeed. And it doesn't matter how many of these you've done, you still should always refer back to the policy. And the policy is going to show you the three main points and what the three main issues in every domain name dispute. And as it relates to trademark rights, there could be a difference by way of example of a registered right versus a common law trademark where you may need to prove use versus a trade name. And it's important to think of trademarks as a snapshot in time. The same way the registration will exist in a certain jurisdiction on a certain day, that same concept exists as it relates to a domain name. That domain name will have been registered on a certain day, either before or normally after use of the trademark. And those snapshots in time are very important as it relates to the trademark at issue in the dispute. Then there's obviously legitimate interest versus bad faith. And again, I'm not going to get into it too much, but I think a good way, or at least the way I think about legitimate interest is there a good faith basis that the registered the domain versus is there a bad faith? Is there some nasty conduct on that website or some nasty reason that someone registered that domain such that it amounts to bad faith? And you think of, by way of example, phishing or cyber squatting or selling counterfeit, just some what I'll call wrongful conduct associated with the use of the domain. That's really on a high level approach as it relates to the overview of a domain name complaint. And we're going to get into, and I think the most fun is getting into the case examples and the differences between the two concepts, which I'll now go to the next slide and hand over to Michael. Oh, and sorry, Michael. Guys, if you have questions, feel free to put them in the chat at any time. I'm happy to respond as we go along through the slides, and same with Michael, but I will now hand it over.
Thanks, David. I've been almost passed the baton 2 or 3 times now. Let's just
sorry.
And
we're eager to hear from you, Michael.
Thanks. I echo what David said. First of all, put questions in the chat right away. I think Barry is going to be looking at them and can jump in and ask us a question if it's on a point that we're talking about, rather than waiting to the end. We're happy to take the questions as we go. And I also want to add my own disclaimer. As Barry mentioned, I am a member of the CDRP domain name dispute panel, as well as the VANIAC commercial arbitration panel. And so none of the things that I say today should be taken as any indication of my views on any particular case or any particular decision. Some of the case studies that we're going to talk about later were actually decisions that I was involved in, either as sole arbitrator or as a member of a panel. And again, comments on the issues there are not to be taken as deciding those issues on any future cases. As all of you probably know, and like David, I would glad to see so many colleagues joining us today. As you know, the CDRP and UDRP decisions are very much based on the facts and the evidence of each individual case. So one of the messages we want to emphasize today is the importance for both complainants and registrants to put those facts and arguments, evidence forward as clearly as possible, so that as a panel member, I want to have everything before me, and the scheme of the UDRP and CDRP has all of the materials being presented in writing. There are challenges for complainants because they have to make the case right up front, even if the respondent never responds to the complaint. The decision still has to be based on the evidence and the materials that are filed in the complaint. And so I'm going to talk a little bit about the overall scheme of the UDRP and CDRP. It's important to know that they're very similar. And the CDRP, in fact, was originally based on the UDRP as it was when the CDRP was adopted. So there are quite a few similarities, but there are also key differences. And one of the things that I've seen both previously as a lawyer when I was working on domain name complaints on behalf of clients, and now as an arbitrator, is that there are references in the materials often, this is particularly in the CDRP, where references are made to UDRP decisions, sometimes because there isn't a CDRP decision on that particular point. But it's important to realize that they're not the same. And so if you're referring to a UDRP decision, you have to be careful about how does that issue relate to the CDRP. And so some of the specific things, if we go to the next slide, one of the threshold questions is, does the complainant meet the Canadian presence requirement? Because that is a requirement to bring a complaint. And that might be a challenge for some trademark owners. If you have a foreign owner who has a common law mark or even an application, but the mark's not registered, that could be an issue. Do they meet the CDR? Do they meet the Canadian presence requirement? They might meet the test for rights under the policy. They have rights, and they may have evidence on all of the other elements that need to be shown, bad faith and legitimate interest. But if they don't meet the Canadian presence requirement, they can't own the domain, and there may be a problem.
Now, Michael,
yes.
Sorry to interrupt so soon, but we do have a question that
Sure.
is actually on this point. I'll just read the question. It's from Christopher Desjardins. With delays at the Canadian Intellectual Property Office in examining trademark applications now reaching 31 months, what suggestions do you have for parties who do not meet the Canadian presence requirements to take action against bad faith domain name registrants in the .ca domain?
Yeah, that's a challenge. David, do you want to answer that one? Because sir, you must have some trademark owners who are in that position.
Yeah, it's an excellent question. So there's two suggestions, and I'll call these value adds. And I've dealt with this issue before. And just for those that don't quite understand, if a foreign entity is not a registered trademark owner, then in order to own a domain name in Canada, they must meet the Canadian presence requirements. And so as a result, there must be some nexus to Canada. So what I've done in the past, in one example, is brought the complainant on behalf of two parties. And so there was the, what I'll call, foreign entity trademark owner and the licensed trademark user in Canada. And that licensed trademark owner also has rights in Canada, which are arguably being impacted. But what it does is it allows that Canadian entity to be included in the complaint, and then they would seek transfer of domain name to that Canadian entity versus to the foreign trademark owner. So that's number one. That's one suggestion that I can give. And number two, and this is a more recent suggestion, is there are significant delays at CIPO, and what CIPO has done is they are now allowing for expedited trademark applications. And what that means is if you satisfy certain criteria, which we'll discuss momentarily, you can, as trademark owner, jump the queue to have that mark examined. So instead of waiting 31 weeks plus for examination, and that's obviously for national marks, not for international marks, you can jump the queue to approximately 1 week. And that is significant. And one of the criteria to convince CIPO why that trademark owner deserves to jump the queue would be if, by way of example, the mark is being severely disadvantaged on online marketplaces. So let's say hypothetically that trademark is going through that type of issue, then you can ask the government by filing an affidavit to jump the queue of examination. You would obtain your registered trademark in a far faster time frame, and you would then be able to use that registered right to, by way of example, to meet the Canadian presence requirement. So those are two suggestions on how to deal with the significant delay. And I can tell you from experience that CIPO has been very amenable to allowing rights owners with legitimate counterfeit issues or being severely disadvantaged online, in this case in online marketplaces, to take advantage of that new practice notice. I hope that answers it, and if not, I'm happy to further clarify in the chat.
Thanks, David, and we'll go back to Michael.
Yeah, and I think that the first point that you made, David, too, is an important one. That there's a Canadian entity, a related company. They may not own the trademark that may be owned by parent company, but they may have rights, and so that will bring them under the CDRP. The other thing I wanted to say, and this is again just by way of example, under the CDRP, the complainant must prove they've got rights in the mark, and they must prove that the domain was registered in bad faith. And there must be some evidence, is what the policy says, that the registrant does not have a legitimate interest. The registrant must provide some evidence, and then, or the complainant must provide some evidence. The registrant must then prove that they do have, the onus shifts to the registrant to show that they do have a legitimate interest. So complainant has to prove the first two elements. The registrant ultimately must prove the third element. The onus is on them. In the UDRP, it's phrased differently. The complainant must prove all three elements. That the three elements are the same, but it appears that there's a heavier onus on the complainant. When you actually look at the cases, though, the panels have generally said that the complainant only needs to have a prima facie case. In essence, provide some evidence, and then the onus shifts. So again, differences and similarities can be fairly subtle. Things that appear to be the same may actually be different under the two rules, and some of the wording that appears to be different, when you look at the cases, the end result is quite similar. And that's why it's very important to actually take a close look at the cases under the UDRP and the CDRP, as well as under other rules that are based on the same model as the UDRP. And there are quite a few other country code domain name dispute resolution policies that are modeled on the original UDRP. And it's worth looking at them too. And we've got a case study later on from the Netherlands, which illustrates that. Can we go on to the next slide?
Just to add, Michael, when you use the word that it's modeled on the UDRP, it doesn't mean it is the UDRP. You still have to go in and actually read the rules for that country code specific dispute resolution, because there are nuances. And believe me, if you read some of the cases that have come out in some of the random countries, those nuanced rules are very important to be aware of.
Yep, exactly. Like the CDRP. And I happen to be involved in some of the discussions, when CIRA was looking at implementing a dispute resolution policy way back when, on some of these rules, and some of the things are, some of the rules are quite intentionally different from the UDRP, and some they simply adopted what the UDRP already had in place. And again, as the cases move forward too, the decisions and interpretation of the rules varies from one jurisdiction to another. So you need to be aware of it. Some other key differences I just wanted to touch on briefly. The CDRP covers registered trademarks, common law marks, pending applications, and business names. The UDRP specifically refers to trademarks and service marks. That's been interpreted as including common law marks, but it doesn't include things like business names if they don't rise to the status of a trademark. So you may have a situation where the rights being claimed under the UDRP are not rights that the UDRP will recognize. The UDRP has a broader scope for determining whether a domain name is confusingly similar or not. Both of those sets of policies include lists of bad faith and legitimate interest factors, but those lists are not exhaustive. And so you need to look at the cases that have been decided to determine what counts as bad faith and what counts as a legitimate interest under each of those policies, and what panels have found to be bad faith or to be a legitimate interest. On bad faith, for example, the CDRP refers only to registration in bad faith. And so the time period that you're looking at is when the domain name was registered. Conduct after that can be used to infer what the intent was at the time of registration. But that in itself isn't bad faith. The UDRP requires both registration and use. And so you have questions under the UDRP, has there been actual use in bad faith? And a lot of cases on that, depending on what the domain name registrant has done. Similarly, the UDRP seems to have a broader scope of legitimate interest. The wording in the policy itself is much more general. The CDRP policy has a very specific list and a much longer list. It has a broad catch-all wording as well, so it's not a closed list. Under the CDRP, there is a good faith element to many of those examples of legitimate interest. And so you have to ask under both those policies, how are the tests for bad faith and legitimate interest similar? Are they two sides of the same coin? If there's bad faith, there can't be good faith. If it's done in good faith, it can't be bad faith. Or how are they different? And there are differences. I'd suggest in looking at the cases, you don't automatically say because we have elements of bad faith, there's evidence of bad faith, that as a result, absolutely there can't be good faith. But they are closely connected. They're certainly tied together, and you see that in a lot of the decisions. So again, just because the wording in one policy or another looks very similar or looks quite different, you have to look at how that wording has been interpreted by the panels under each of the policies, and link that to the evidence in the particular case, whether you're acting for the complainant or acting for the respondent. How do we prove or disprove the elements, each of the elements that's necessary for a successful complaint or a successful response. And with that, I will hand it back to David.
Thanks, Michael. Very important points. Before we move on, I just want, really before we move on with the cases, I just wanted to quickly go over the slide, brand integrity. And it's important to think about the actual complaint. The entire purpose of this dispute is to essentially either transfer ownership of someone else's domain name to a rights owner, or have the registrant keep the domain that it initially registered for whatever reason, if it was done by way of example in good faith. And the reason it's so important to think about this is because there's a lot of bad faith conduct, or there's a lot of wrongful conduct or infringing uses of what the website might be in actuality that is technically outside the scope of the domain name dispute exercise. And although those points may be used as evidence and it might help you succeed in your domain name dispute, at the end of the day, it always comes down to the test, which we discussed briefly, the nuanced differences between the CDRP and UDRP. And of course, it always comes down to the domain name itself versus the mark. And so the reason it's important to think about is because there's a lot of wrongful conduct online, and if it's not going to relate to why the domain name should be transferred to the rights owner, either it's not relevant for the dispute itself, or it's harmful to the brand, and there may be some other tool in the enforcement toolbox that the rights owner should look at. And the best example that I could think of is if the site's selling counterfeit, there may be other options. It might be a dispute with the ISP where, you know, it's removing certain content online. But if it's not domain name specific and it's not about the ownership of the domain name, then use a different tool, because this is just one tool in the brand owner's toolbox. And it's important to think of in that regard, because if you find some of the losses where the domain name, or sorry, where the rights owner does not acquire ownership of the domain, there may have been another tool available that would have achieved the result that the rights owner wanted. And so it's an important thing to think about at the infancy of the case when you're looking at your request from your client, or when you're looking at the domain for the first time, to say, what do I do? What do you do? The domain name dispute resolution policy and the request for transfer of the domain name, that's one tool in your enforcement toolbox, and it's a very valuable one. Acquiring ownership of a domain name is really important, but I just want to repeat, because it bears repeating, it's just one tool and there's lots of different tools. So with that, we'll move on to the next slide, Michael.
Thanks. So now we're into the case studies, and David and I will speak about several cases that we've that we think illustrate some interesting points about the UDRP and the CDRP. So if we go on to the next slide, please. This is a very recent case from earlier this year, and it is an example of the kind of case where the complaint fails because the domain name predates the trademark rights, and so it goes to the first element that has to be proven by the complainant, that the complainant has rights, and also to the question of whether the domain name was registered in bad faith. And in this case, the domain name was registered quite a while before, it's in 2002. The trademark application was filed in 2021, and the complaint was made fairly soon after that. Now there was a prior mark. This is the complaint. The complainant in this case was the Indian pharmaceutical company, Dr. Reddy's Laboratory. And they had a series of products. So they had a prior similar mark since 2015. And if you sounded it out, it was similar to this 2DG. And they had a line of products. They adopted a new trademark later, and the complaint was based on that trademark, 2DG. So under the UDRP, they had rights because the time for looking at rights is when the complaint is filed under the UDRP. So they met that hurdle, but they failed at the second hurdle, which was bad faith. And the panel really quite simply found, well, there was no bad faith registration because the domain name was registered long before the trademark was adopted, even before the prior trademark was adopted. And the complaint failed. We'll go on to the next one.
Thanks, Michael. I will handle this one. Every complaint usually comes down to one factor, right? Usually bad faith, sometimes legitimate interest, and then in certain cases, rights in the mark. This is one where we're going to go over all three. And just to be clear, first of all, I don't know who brought this complaint, and it's really easy to, as counsel, to look at a decision after it's been rendered without having access to the complaint or the response and think, well, this is what I would have done in that case. It's really easy to do after the fact. These cases are not so easy to decide at its infancy, meaning what should I do when the file comes across my desk? And so don't think that just because we're commenting on, what could have been done differently, it could be, for example, in this case that, everything was done right, but for a variety of reasons, the case was lost. So I don't want to think that we're passing judgment on any of the on any counsel or on any rights owner that brought these cases. Instead, we're using them as valuable learning lessons on how to guide our clients in the future. And so I just want to be clear.
If I jump in there too, I meant to say at the beginning of the case studies, the complaints that aren't successful for learning purposes are usually the most interesting. The vast majority of complaints are successful. A lot of them are kind of slam dunk cases where the complainant has no problem proving all of the elements. It's the ones where they don't that provide useful instruction, I think, for those who are either bringing complaints or acting for respondents in the future.
That's absolutely right. And that's a perfect segue into the FPL case, which Forest Protection Limited brought, and that was the trademark. Now, this domain name, fpl.ca, was registered prior to the trademark application filed. And so the trademark application filed had an earlier use date back to 1952, but in this case, the complainant didn't provide evidence of prior use. And so that may have been one of the reasons for failing to establish any trademark rights. As it relates to bad faith, you hear this all the time, 2-3-letter domain names. These are tough cases. 3-letter domains, 2-letter domains, those are inherently valuable to a lot of people. And as a result, there could be squatting on a 2 or 3-letter domain that has a completely legitimate purpose. And so what happened here, the screenshot that was showing the domain name along with an offer for sale was not evidence of bad faith in this case. And the registrant provided evidence to support that it didn't register in bad faith. They had a legitimate reason to register the domain name. And by way of example, FPL, there were 150 plus FPL formative marks. And so who's to say that it was done in bad faith versus Forest Protection Limited? I'm pretty sure this was a case, it might be another, but pretty sure this is one where the registrant said, I've never even heard of Forest Protection Limited. And you will get those types of responses in what I'll call the more challenging cases, or in this case, the 2-3-letter domain name cases, where there can just be so many different meanings to those 3 letters to so many different people. And so the panel in this case decided that the screenshot showing the domain name parked and offered for sale was relevant to legitimate interest, and there was no other evidence on this issue. And so it was found in favor of in this case, of the registrant. And I think as a value add from the rights owner perspective, because the truth is, I wish the domain was transferred to Forest Protection Limited. I'm biased on the rights owner. And the value add is, if you have a 3-letter domain, and if it is a difficult case to prove right at the forefront, try and combine it with some other form of wrongful conduct. So in this case, obviously, the offering for sale wasn't enough. Fine. What if, by way of example, this registrant owned 100 other domain names that belong to other trademark owners? Maybe that fact might have helped tip the scale. And so what you want to do when you have the challenging case is try and come up with other reasons to convince the panel as to why it was registered in bad faith, or as to why there is no legitimate interest. And another example I could think of is, by way of example, let's say there were, in this case, phishing emails sent out, or let's say there was some other wrongful conduct to package together to say this domain name was clearly registered by the registrant, bad guy, therefore ownership should be transferred to the rights owner. This is one case that maybe might have swung in favor of the rights owner with different evidence. But again, I'm looking at it from a bird's eye view after the fact without access to the complaint or the response. So easy for me to say what should have been done. And with that, Michael, I'll pass back to you.
Okay. Yeah, you're absolutely right on that case, and looking at other cases kind of after the fact. I think the message from that and other cases is marshal as much evidence and as much support for either side as you can, and put it all before the panel, because in most cases that is what will determine the outcome. Here's another interesting one that we found, and there were 3 cases under the UDRP, and all 3 complaints were successful. The Unemployed Professors is a group of people who have a university essay writing services business. I'm not sure whether they're all actually unemployed professors or not, but in any case, the panels in those complaints determined that the complainant, which had started this business sometime earlier, had common law rights in the mark Unemployed Professors. And there was evidence submitted about the use of that phrase as a trademark. They also owned the domain name unemployedprofessors.com. And so all 3 of these complaints, I believe against different registrants, in any case, separate complaints, all looked at that body of evidence, at the evidence that was submitted, and found in favor of the complainant. So common law marks and prior use, prior registration of the unemployedprofessors.com domain, put a timestamp. They had records of when they started this business, and use of the mark in a variety of ways, not just on their own domain, but other evidence of use of the mark, and they were successful. Back to you, David.
Thanks, Michael. That's great. Just on one point specifically that I want to introduce now before we move to the next slide, as it relates to filing responses. And oftentimes you'll have a complaint submitted and there'll be a response from the registrant. And then what the complainant will do is they will attempt to file supplementary evidence, which there's no automatic right to put before the panel. And that's why it's so important to put your best foot forward at the moment you submit the complaint. as a rights owner, you don't want to save an argument depending on how the registrant responds. Typically, once you get into a he said, she said, or once you get into additional facts outside the scope of the initial complaint file based on a registrant response, these become really difficult for a panel to look at and say who's to be believed. By way of example, there's no cross-examination. There's no, witness in a box that the panelist gets to look at and say, that's the person that I believe. And so as a result, these are what I'll call paper arguments or paper submissions, and it's a written record. And as a result, this is why, in my mind, it's so important to put your best foot forward. Having said that, I file supplementary responses all the time. As a lawyer, I want to get the last word in every case. And so I often file supplementary responses. I'm not saying don't file them. What I'm saying is put in everything that you want to submit in your complaint. And then when it comes time to asking the panel to look at a supplementary response, it is precise, and you are literally picking an argument the respondent gave and saying, here's why it's or here's why it shouldn't be believed. You're not going in and talking about the three factors and what could have been argued earlier. And so my advice on that point, which I think is relevant, is put your best foot forward right at the get-go. Number one, you gain credibility with the panel. Number two, you don't want to have to come back and have the panel say, why am I learning about this now in a supplementary response? And that's even if it is accepted for filing. Oftentimes, the supplementary responses are not accepted for filing.
If I could just throw in a couple comments in addition to that, David. One of the things to remember if you're acting for a complainant is that a large proportion of the complaints, there is no response filed. But the complainant must still prove the case. There's no point in holding back, an argument, or, I think there might be a temptation from some complainants or counsel to say, well, we don't want to make the respondent's argument for them in our complaint. And when I was doing complaints, I felt that myself. I don't want to raise an issue if I don't have to. I don't want to put anything in that might highlight some weakness in the timing of the trademark registration or whatever element it is. And so I won't put it in the complaint. But then if there's no response, there's no opportunity to file any additional material. And the evidence just simply isn't there for the panel. So the panel will look at the complaint and say, well, there's a big hole here. And we can't find in favor of the complainant based on what we have before us. And there are cases, have a look at cases, there are cases that were undefended that didn't succeed anyway. And
that's right.
Generally that's because,
go ahead, Michael.
Well, generally that's just simply because the complainant did not want or tried to skate over something that they thought might be a weakness and didn't make their case.
I'm just going to interrupt you, give us a little gentle nudge, just noting the time.
Okay.
We still have, I think, about 10 slides to go. So in the next 10 minutes.
No problem. What I will say is on this point, because I think it's a really important point, is as a lawyer, this is why I think of it as bringing an ex parte motion before the court. Ex parte meaning there's no one else in the courtroom but the plaintiff or the rights owner, moving party, and the judge. And so if you think about that in the context of bringing a written complaint on a domain name dispute, assume it's just you and the panel, and you want to hit your bad facts up front. And when Michael mentioned glossing over, skating over, I don't want Michael to be looking at a fact and say, well, what does this mean? I want it front and center, and here's why my argument is right and should be accepted. Because if you do gloss over it, you're probably going to come off on the losing end if you haven't hit it right front and center. So with that, we can move on to the next slide. Thanks, Barry. This case, Investment Finder, really interesting case that I get to talk about because Michael was the panel on this case. And what I'll say about this case specifically, for those that aren't aware, Fidelity Investments obviously owns registered trademarks in Canada in association with their broker services. Like, I don't know exactly how to describe it in their trademark, but what they do say in their trademark is that Fidelity Investments disclaims exclusive use of the word investment. And so there was a disclaimer in the registered trademark, Fidelity Investments, which was certainly relevant to the panel because, as you know, by looking at this domain, Fidelity is not in there. It's just investment-finder.ca. And this is one where rights in the mark on behalf of Fidelity failed. This is a case that's interesting to me because there was this bad conduct, wrongful conduct on behalf of the registrant, where there were spear phishing campaigns and other types of wrongful conduct taking place. But that's different from the issue on behalf of the domain name itself and the fact that there are multiple people that can use, by way of example, investment. It's arguably descriptive. Is it distinctive? Those are some meaty issues to look at. I think that if this was me arguing the case, funny, Michael, I would still bring this case on behalf of my client. I would still try and make the argument as to why there are rights in the mark and to why they are confusing, but it certainly has to be packaged in a different way. Perhaps either not with a trademark that's been disclaimed or showing through evidence all the use of investment by Fidelity. And Fidelity, I'm sure, has a ton of use of investment, what I'll call outside the scope of the registered trademark. And so I think that's the learning lesson on this one is if you're going to come with a well, I don't want to say generic domain, that's a bad way of putting it, but if you're going to come with a domain that's arguably descriptive, arguably low on the inherent distinctiveness scale, then you got to give the panel what it needs to show that there's rights in the mark and then how it's being infringed. So with that, we'll move on to the next slide.
Yeah, thanks, David. And I think it's, if anybody's interested in looking at that case, the other Fidelity cases, Fidelity Global, Fidelity Bonds, which were successful, are on the same fact pattern, same kind of conduct by the registrant, are instructive as well. And so I'm going to talk about another case that's very similar in terms of the facts, and this is AXA. AXA is a large insurance company and sells investment products, and the complaint involved very similar evidence, and we found this decision as well as the other Fidelity decisions from preparing for this webinar. So similar allegations of phishing and financial scams, lure somebody onto the website to apply to purchase some sort of investment and take their money. What was interesting here is the consolidation of 16 complaints under the UDRP, and they were consolidated under the rules that allow that for the UDRP. And I'll just briefly mention the factors that the panel looked at in considering, deciding that the domains were under common control. Similar format, the trademark along with a descriptive term related to the business. So various versions of AXA, something to do with investments or insurance or what have you. Registered under the same name or with the same register. registrar. Now, not all 16, but there were some common elements that crossed over among those 16 registrations. IP addresses, the name server. They were registered or they were updated on the same date or very close in time. They were used in a similar manner. So there were a lot of common elements on the websites that were associated with those domain names. Some of them, I think, were simply forwarded to others. There was essentially, there was a large group of domains, and they were all used to lure people in connection with these scams. And I gather now, now that I've become familiar with it, that this is pretty common in the financial services industry. I mean, the scammers will take a trademark, and somebody that's searching for Fidelity or AXA will somehow stumble across these sites and get lured in. So contrast the Fidelity decisions among those decisions, and contrast the AXA decisions. And then David's going to talk some more about consolidation of complaints, I think, in the next section, right?
Thanks, Michael. Let's move on to the next slide. And I am really excited to deal with this issue specifically because there are only 3 ever cases before the CDRP as it relates to consolidation. The issue being multiple registration to one registrant. I acted as counsel on all 3. You were a panelist in one of them, the one that I lost, and I only ever lose cases where the panel got it wrong. So I'm just joking, obviously. And the reason I want to talk about the case is because it's an important issue, and it is common, and not just in the financial space. It's common as it relates to the anti-counterfeiting and what I'll get into as that wrongful conduct issue. What's happening is you have these registrants that are trying to stay one step ahead of the rights owners. And in doing it, by way of example, they are registering multiple domains, and then they'll, by way of example, they'll go live with those domains at staggered different times. The moment the rights owner shuts down one, they'll then turn on the other. And there's a variety of different mechanisms available to these registrants that really what they're trying to do is evade enforcement. And so what happened in this case, and the reason I call it round 1 is because, and this is all public, obviously, but if you go to the CDRP website, you'll see there were 2 complaints filed on March 18th on behalf of 2 different of my clients. Birkenstock filed a complaint against multiple registrants, and Calvin Klein filed a complaint against multiple registrants. And these 2 cases were brought forward at the same time, and there were decisions released on the same day with different outcomes. And the reason I think it's so important to talk about is because, number 1, because I lost, so there's a learning lesson involved. But number 2, because it is a unique issue and it is a unique, nuanced argument. And the argument is as follows. Although there are different names in the registration listed in the who is, and so when you file a complaint, CIRA will tell you, here is the registrant, and you'll get a name, you'll get an address, you'll get an email address. The position taken by both Calvin Klein and Birkenstock was there's one registrant, John Doe, with multiple aliases that have registered multiple domains. And so in this case, the arguments that were submitted, and if we just look really quickly to the next slide at the pictures that were before the panel in these types of complaints, we're finding commonalities. You're finding common ISPs, you're finding common, by way of example, MX records to send out emails. You're finding the sites all have the same look, the same feel. And so the next slide, if we look at these pictures, Ina, you will actually see, by way of example, here are those commonalities. And so the rights owner says, well, hold on a second. I have the same websites with the same wrongful conduct that all follow the same format. I'm going to package it together, and I'm going to argue as to why this is, in fact, one registrant. And so in this case, we can go to the next slide. This case was lost, the Birkenstock case. And then it was subsequently brought at a future date before a different panel. And there was one added factor, and we'll go to the next slide and you'll see it. What happened in this case was we actually provided the ownership details for the properties. One of the properties, this one that we gave, it didn't go anywhere, but there were actual registered properties to the registered, what I'll call owner of that domain. And the point being, those are just random details belonging to random people. And the argument to the panel was, they're not real people, real respondents. It's one respondent at the top, and they've just created fake or fictitious names, fake or fictitious address, even real addresses that belong to real people. It shouldn't matter. The fact is, it's all one person. That's the pitch, and that's the argument. And it's a lot easier to do in the UDRP. And there's now 2 cases for in the CDRP and 1 case against. And the argument, and if you want, just because I have it handy, the argument to submit was twofold. Number one, we showed what the rule says in the CDRP, in the rules and the policy. And it says, for greater certainty, a proceeding may be only between one complainant and one registrant, regardless of the number of such registrations. So the argument was, this was one registrant, despite having multiple names. And then if you look at paragraph 3.2L of the policy, it states that you can provide a summary of and references to prior decisions in Sierra or dispute resolution proceedings. And so what we did here is we took the WIPO overview, because the rules are very similar. It can't be multiple registrants. It has to be one registrant. But what you can do is argue why multiple registrations belong to one registrant. And so because the WIPO overview has such a storied history behind multiple registrants, it was helpful argument by analogy to say, here's why this should apply in Canada as well. And then obviously there's a varying number of factors. The most important point, obviously, on behalf of the rights owner is, hi panel, this is one registrant, despite the fact that there are multiple names. And any lawyer will tell you the hardest thing to prove in court or before a panel is proving a negative. And that is what is being asked of the panel in these cases. So you better come forth with really strong evidence that sets it out to make it as easy as possible for the panel, especially when there now are conflicting decisions on this issue. And again, you're proving a negative, not so easy to do. And so having said that, on this issue, I do think it's going to be a continued issue. If we go to the next slide, I love this case, because this case, although it's not a multiple registrant issue and it's not a consolidation issue, it hammers home the exact argument that was being made in those previous 3 cases. Easy for me to say because they were all my cases, but this case isn't my case. And in this case, what happened was the complaint was filed by the rights owner, and the respondent, meaning the listed registrant, filed an affidavit saying, guys, that's not my domain name. I never registered this. And that's exactly what we're saying in the previous 3 cases. The fraud that's being committed by the registrant, by the actual registrant, is using aliases to satisfy the Canadian presence requirements. And if that's happening, you're going to start getting more and more what I'll call difficult issues to put before the panel. This, in my case, the enterprise rent, it's a slam dunk case. And it's not often you have a respondent filing a response saying, I never registered this domain name. Well, it's like a gift from God. I wish I had that in all my cases. But in this case specifically, obviously, the true registrant, they don't respond. And so I think the value add and the learning lesson in what to do with these types of cases going forward is, if it's a rights owner and you've got all the wrongful conduct and there's no response expected by the registrant, then you have to put in every relevant detail to make the panel's job as easy as possible to side on behalf of the registrant. And so by way of example, my client in the first Birkenstock case, we did not pull ownership records of the addresses. We did that for the second one. we didn't feel that it was necessary, but it was one extra fact we could have given to the panel to hopefully tip the scale into our favor. Learning lesson. The losses are what gives us the nuggets on how to win every case. And so with that, I will pass it back to Michael with thanks.
Thank you. And I'm conscious of the time, so we've got a few more cases. On those cases that you just talked about, David, and actually the previous cases as well, the AXA where there was consolidation. One of the points on the CDRP, and all three panelists agreed in those three decisions you mentioned. The Canadian rule refers to an indication on the register that the registrant is the same person. And so the evidence from the registrations themselves, I think, was important. And I've had a chance to look at the second Birkenstock case decision as well. And I think that was certainly a factor when you brought forward, that evidence of a false address, a false name, false contact information, those kinds of things. And the UDRP decisions speak to the same kind of evidence as being, as showing that, able to draw the inference that it's the same registrant when there's false contact information in the registration. So here's a couple other cases I want to talk about, and these illustrate the danger of allowing a licensee or a potential licensee or partner to register the domain name. In both of these cases, a Canadian entity had registered the domain name. They were in discussions with a foreign owner of the trademark. When that relationship collapsed or ended for whatever reason, the trademark owner sought to recover the domain name and the registrant refused. Both complaints were unsuccessful. In the Truck Suite case, the complainant hadn't established that there were rights in the mark when the domain name was registered, that it had been used in Canada. And there was a dispute over whether this was with the approval or knowledge of the complainant. The DISO Canada, there were rights in the mark, but the complainant didn't show bad faith registration or lack of legitimate interest because there was evidence that it was registered, the domain name was registered with the permission of the trademark owner based on an oral agreement. Now, there was a dispute over the existence in terms of that oral agreement. But in both of these cases, you question whether the domain name dispute resolution process was the right forum to argue those rights. And in both cases, the complainant failed. And I think in both cases, the panels thought that it wasn't. There were more evidence and issues there that needed to be determined than could be done in this forum. So the next slide shows a couple more recent cases, and in both cases involved domain names that were registered before the complainant had acquired trademark rights, and there was evidence of unsuccessful negotiations to buy the domain name, and when those negotiations were unsuccessful, the complaint was brought. In the agreement.com decision, the complainant didn't prove bad faith registration and use, but the panel did not make a finding of reverse domain name hijacking and penalize the complainant for bringing the complaint. In the clear.com the complainant didn't prove bad faith, so it failed on that ground. But the panel did find that the complaint was made in bad faith and was an abuse of the administrative proceeding. So these types of cases can go either way depending on the facts of the individual case. If the respondent responds and asks for a finding of reverse domain name hijacking or complaint made in bad faith, as they're able to do under both the .com and .ca rules. And then our final case is the next slide. And this is the Instagram.nl decision. Do you want to speak about that, David?
I do, thanks. Yeah, before we do, I just want to answer that question that came in through the chat, the reverse domain name hijacking and CDRP and possible consequences. Although I haven't looked this up in a while, the consequence would be a $5,000 payment by the complainant to the registrant. So that's a pretty significant consequence for what I'll call filing a complaint in bad faith. So what are some examples that I've read in the past? A rights owner that doesn't own any rights, that's just solely trying to acquire domain. So think of the most generic term in the world. And let's say hypothetically, there's no registration for that generic term, yet a complainant files a complaint. So if the facts are egregious facts where you look at this complaint and say, I cannot believe that a complainant will be brought in these circumstances, that's sometimes where the reverse domain name hijacking will be triggered. And so that's the answer to that question. Now, as it relates to Instagram, the only comments that I wanted to make when we look at this, not that it's a reverse domain name hijacking, so don't think that just because of the timing of answering that question, but this is a really important one. It's a .nl, so it is a what I'll call a country code top level domain. And it's an important thing to think about because in this case, Instagram, they paid for the .com. They paid significant dollars for the .com. And so this is one where Instagram, where if you look at the response and the filed response that was cited in the decision, there was a legitimate reason for creating this business again back in 2010, which in the Netherlands, Instagram probably had no meaning to that registrant at that time, and that bona fide business plan, to the extent that it was true, would certainly give rise to an adequate response. So in this case, the money that was spent on buying the Instagram.com domain, probably a similar outcome, although this was a very recent case, so we don't know how it's going to play out. But you got to be careful when you decide to bring these complaints. Your time delay hurts. Use if it's a generic name or if what I'll call an inherently weak trademark, those cases are really tough to prove. And so you, again, when you think about these different domains, you want to make sure that before you bring the complaint, you've thought about all the arguments at the time it's filed initially. Anything else to add from you, Michael?
Yeah, David, the Instagram decision is interesting, and it highlights something that some of the earlier cases that we talked about do. When there are other factors kind of outside the scope of the domain name resolution process, and in that case, the panel, went through the facts and the history of the dispute, including that the complaint had been adjourned. Process had been adjourned for a year for mediation, and you shouldn't think that should be a factor one way or the other. But obviously, there were a lot of facts involved, and the decision says the panel finds there are questions of fact here that require resolution of a kind that is better suited for a court. For example, with potential discovery and party examination, and so did not find in favor of the complainant. And I would say questions of fact, but also in some cases questions of law, of who has rights, for example. And in those cases, it may be worth filing a complaint, and it might be successful if the facts are aligned and the panel agrees. But in some of those cases, it might think about, do we even want to file a complaint, or are we better going to court because there's other issues here that need to be decided, and the domain name panel isn't going to decide those issues.
That's right. And just if there's any another learning lesson we can give in these types of disputes, again, it's another loss. And I had some really good advice given to me the first year of my career when there was a very small case, it was a small claims court case, and it didn't go my client's way. And my mentor came to me and said, it's okay to lose. If you're not losing, it means you're not bringing enough cases. And so the truth is, you're not going to win every case. And it's winning the tough ones that, we take the lessons from these types of cases and then we apply it so that we can succeed in the future. And so don't be deterred if you have a case where the outcome was not decided in your client's favor. Don't let that deter you from continuing to bring cases. I'm here to say I've lost. I don't like losing, but it doesn't mean that you stop proceeding with these types of complaints.
And
So with that, questions?
The UDRP and the CDRP, I think the overall message that we want to bring to everybody is that these are very useful tools for trademark owners, but it's not always the right tool for the job, and you've got other tools in your toolbox as well. But where it is the right tool, make sure that all the I's are dotted and T's are crossed, and all the evidence is before the panel, so that the panel will make the right decision.
That's right. Thanks, Michael.
Okay, I think, is that our last slide in the deck?
Questions?
So we've answered a few as we've gone, but if people have additional questions, feel free to put those forward. We do have a few more minutes.
Yeah, I appreciate everyone. Everyone asked really, really good questions. So thank you for that. For those that didn't log in, one of the questions was the standard of proof in UDRP, balance of probabilities. It's the same in the CDRP. So that's not a difference. It's the same. And so thank you for that question. And don't be shy. Feel free to type anything in now that you have the expertise of Michael and I.
For what it's worth.
The 2 cents for mine.
All right, I'm not seeing a great stampede here of additional questions. I'd like to thank everybody for participating, but especially our two presenters, Michael and David. Very thorough and thoughtful presentations. We delved into this rather unique and discrete component of intellectual property law, protecting your domain names. And, we could have said this at the top, these things are often worth fighting for. Domain names often trade for multiple millions of dollars, sometimes approaching, what was it, LasVegas.com sold for, I think, $90 million in structured payments over a number of years. So there's at times significant dollars at stake, and brand reputation is, of course, extremely valuable at protecting that. So again, if you have any further questions following this, go to our website, CIIDRC.org, and you'll come to our interactive website, and you have all the contact information to reach us. And I'll just give a shout out here to the person you have not seen, but operating behind the scenes. Ina Aragashiva is our deputy director, assisting with all of this and keeping us on track here today. So feel free to contact us, and Ina or myself, someone else, will make sure we get back to you. Again, thanks everybody, and have a great Monday.
Thanks for joining, guys.
Thank you.